What happens when a simple parking ticket, on your own street, mind you, suddenly explodes into a full-blown legal showdown? Well, we're going to dive into a really fascinating case where one homeowner decided to take on his entire HOA over a single piece of paper, and it all comes down to a huge question: who really controls the streets we live on?
And this is the question, right? It's really at the heart of this whole story. I mean, it's a situation a lot of us could probably imagine ourselves in. The street's public, the city takes care of it, anybody can drive on it. So, how in the world can a private group like an HOA claim they have any say over it? That's the exact question one resident decided he was going to get an answer to.
All right, so let's meet our main players. On one side, you've got the homeowner, Thomas Hommrich, and on the other, the Lakewood Community Association. And believe it or not, this whole thing kicked off with something pretty minor. It wasn't a huge fine, it wasn't a tow truck showing up, it was just a simple courtesy violation notice for parking on a public street.
And wow, what started small escalated fast. So the notice shows up on February 2nd. Barely 2 weeks later, Mr. Hommrich fires back, and he isn't just denying the violation. No, he's challenging the HOA's basic right to even issue it. Fast forward to October, and this is no longer a friendly neighborhood chat. We're talking a formal legal hearing. It just goes to show you how quickly these things can spiral out of control.
Now, this is where it gets really interesting. See, Mr. Hommrich didn't just show up and argue about whether it was fair or not. Oh no. He came prepared with this super technical and honestly a really clever legal argument. He went deep into the HOA's own rulebook, their governing documents, to challenge their authority from the inside out.
His entire case, the whole thing, it all hinged on the specific legal meaning of one single word: restriction. See, he pointed to this key clause in the community's founding documents, their CC&Rs. It basically says the public property isn't subject to most of the community's rules, except for restrictions that are written into that main document. So his argument was simple, right? If you want to tell people where to park on a public street, it has to be a formal restriction, period. And you can see his chain of logic right here. It's brilliant. He built this step-by-step case using their own paperwork. He said, okay, step 1, the policy you ticketed me under is called rules and regulations. Got it. Step 2, your own CC&Rs say that rules and regulations are considered association rules. Step 3, those same documents explicitly say association rules can only apply to common areas, like the pool or the clubhouse. So step 4, the conclusion. A public street is not a common area, therefore your parking policy has no power there. I mean, it's a thing of beauty, legally speaking. And he really summed it up perfectly himself during the hearing. He said this was all about the HOA blurring the lines between rules and restrictions. See, for him, this was never just about a parking ticket. He was fighting what he believed was the HOA twisting words to grab more power than they were ever supposed to have.
But, of course, there are two sides to every story, right? The HOA saw things completely differently. From their perspective, they weren't blurring any lines. They believed they were operating exactly within the power they were given from day one. So the HOA's lawyer pointed to a totally different part of the rulebook. First, they brought up Section 4.2t, which says flat out that the original intent of the community was to eliminate on-street parking. Then they point out that the very same section gives the board the right to create more parking rules and restrictions. And to top it off, Section 12.2 says any new rules they create have the same force and effect as the original founding documents. So, their case was pretty simple. The authority is right there in black and white. And this all led to their main argument, which you could call stacking authority. They argued that this new parking policy wasn't some illegal change to the main rules. Instead, it's like an extra layer that stacks right on top of the original CC&Rs. They're basically saying, hey, the original document gave us the power to make new rules, and that's exactly what we did. It's how they believe a community is supposed to evolve without having to rewrite its entire constitution every time a new issue comes up. So this is really the heart of the conflict, this showdown over words. You've got Mr. Hommrich on one side saying, nope, this policy is a rule, and that means it can only touch common areas. Then you have the HOA on the other side saying, no, this is a set of rules and restrictions, and our founding documents give us the clear authority to make them. It really all boils down to one simple but crucial question. Do rule and restriction mean two totally different things, or are they just different words for the same kind of power? Okay, so after all the back and forth, all the deep dives into legal definitions and all these different clauses, what did the judge think? How did the court finally settle this battle of words?
Well, the verdict was clear and decisive. The judge dismissed Mr. Hommrich's petition and ruled completely in favor of the HOA. The ticket was valid, the policy stood. The big question, of course, is why?
The judge's reasoning basically sliced right through that whole debate about the meaning of words. While Mr. Hommrich was zeroed in on the semantic difference between a rule and a restriction, the judge was looking at something much more fundamental: the actual authority the board was given. In other words, the judge didn't really care what they called the policy. What mattered was whether the HOA had the power to create it in the first place.
And this, right here, this is the knockout punch from the judge's final decision. He wrote that the homeowner's whole argument about the semantic difference between the terms was irrelevant. Ouch. The court's logic was that since the board was given the authority to make parking rules and they followed their own process to make them, then the policy was valid. It didn't matter what specific word they used to describe it. So, what's the big takeaway here? What does this ruling mean for you and me? Because this was never just about one parking spot in one community. No, this decision gives us some really important clues about how HOAs work and, maybe more importantly, how courts view their power.
All right, so let's break down the key lessons from all this. First takeaway: intent can trump semantics. The court cared more about the original goal, to eliminate street parking, than the specific words used. Second, those little clauses that grant a board power to make new rules, they are incredibly powerful. Third, process is everything. The HOA won because the judge found they had the authority and they followed their own rules to create the policy. And that leads to the final point. If a rule is created with the proper authority, well, then a rule is a rule. The parking policy wasn't a violation. It was seen as a valid extension of the HOA's power.
And all of this leaves us with one last big question to chew on. Think about it. This entire saga, from a simple courtesy notice all the way to a judge's final order, it all came down to the fine print in documents that were probably signed years, maybe even decades ago. It really makes you stop and think, doesn't it? Do you really know what's in your own community's documents and what powers you might have signed away?